Thug and Shannon both knocked out, bro. Look at this.
The state's been caught before. Specifically, I remember a late discovery disclosure that once it was disclosed, it actually had a comment on there that was supposed to be internal that said, do not serve yet. They did it on purpose. And how many times can you say, oops? How many times can you repeatedly, systematically make the same mistake as an experienced litigator and say, it's not bad faith?
The prosecution in the Young Thug YSL RICO trial has made yet another massive mistake. The state gave over more late discovery to the defense, and they've been warned several times to hand over everything for over a year. Are any of us surprised that they withheld more evidence? No. The evidence itself is not important at all. They're not even going to use it, but they didn't give it over. That's the main issue here. They should give over everything by now. We're 19 months into this trial, and they've been caught before purposely not sending over stuff. You'll see later in this video. I'm dropping merch within the next few days, so keep an eye out for that. I'll put it in a video. Hit the join button down below. Let's get right into this video, boys.
They were able to, this is still information in the wiretap, but there was communication from Mr. Boyer.
Okay, so when we're saying cell records, it's essentially like location information.
Yes.
Okay.
Regarding state's assertion that we were put on notice about Mr. Boyer, there is a wiretap. That is true. We were provided the contents of the wiretap. That is also true. There's nothing in the wiretap. There's a phone number, which is what the state handed over on Monday, the contents of that phone number that shows contact through the wiretap. There was nothing linking that phone number to Mr. Boyer. I just want to make that clear.
Okay,
there's nothing that puts us on notice that Mr. Boyer is a person of interest or potentially at all involved or in contact with our clients in this case. And there was also, Mr. Harvey's also pointing out there was no raw data provided in the wiretap regarding the wiretap itself. We were aware of what numbers were calling what numbers.
You just weren't aware that whatever this number is was connected. It's obviously somebody's, but y'all didn't know whose phone it was.
And I can state in my place as an officer of the court upon information and belief that I've listened to pretty much all those calls. I don't recall in any calls in the wiretap where that number's involved anyone ever saying any government name that would put us on notice and say, oh, that's DeMarco Boyer's number. So we've been pretty diligent.
Potentially by the time of the affidavit, but certainly by the time these cell records were secured in the fall of 2023, you knew that that phone number was connected to DeMarco Boyer, true?
That is true.
Okay. So is there a way that the defense was supposed to have also known that that phone number was connected to DeMarco Boyer?
So DeMarco Boyer is a guy that got arrested back in December for shooting in November for murdering someone. I guess they wiretapped his phone in connection to this trial. I don't really know anything about that, but apparently it didn't go very well, and they didn't disclose everything to the defense, and that's what's happening right now. So more discovery violations of the state. I don't know how this trial is continuing.
Yesterday, we were told that it was, to my understanding, an inadvertent oversight by the state to hand over these records. Now we're being told it was a conscious decision not to hand over the records.
How is there not a discovery cutoff? And now they're flip-flopping the reason why they didn't give it over.
Affidavit for the search warrant for Mr. Boyer's, presumably Mr. Boyer's phone records. I specifically requested that yesterday via email, and I haven't received it either.
Emailed request from Mr. Schardt last night that said, could we please have the affidavit in support of the cell record?
I did not. And the court is welcome Mr. Schardt to look at my email.
I'm sure you get a lot of emails.
I want to be very candid with the court. I sent this to Mr. Atkins because he was the one that sent the information.
Well, that's why you didn't see it, Ms. Love, because it wasn't sent to you. It was sent to someone else.
Because he was the one that sent us the phone records. And I want to be clear, and I think it's clear what I wanted, but my email said that I wanted to see the search warrant, which we haven't received either.
That yesterday you said it was inadvertent, and this morning you're saying there was a decision made not to share this information with the defense because Mr. Boyer had not yet been arrested and APD was contemplating whether to secure a warrant, and I didn't want to alert him. So which is it?
They are both. I asked the court yesterday, so I mean, in time to speak with team members.
Right.
And the information internally that I know is that when the phone records were initially secured.
In the fall of 2023?
Yes. Yes.
Okay.
When they were initially secured, the thought process was, we're going to get this person arrested and indicted.
Okay.
As time went on, our team had the records, and as we advanced in trial.
Because, I mean, do you think that it's reasonable that at least by that point you should have shared that information with the defense?
I think that when we're talking about realization and oversight, that at least at that point, if not sooner, at least at that point, that is when it was, oh shoot, I should have turned this over way earlier, at least by then. So initially there was this belief and understanding that there was this investigation that would lead to an imminent additional person charged. That has not occurred. And there was the realization that we have in our possession this data that we need to turn over.
State intend to try to talk to him?
We were not going to talk to him.
Okay. Does the state intend to use this plotted out, whatever y'all got about his cell phone location at different times?
No, not in our position.
All right. And all the information you, the state, have regarding Mr. Boyer is inculpatory of these 6 defendants, or not all 6 of them, whomever is charged in the Thomas murder? Drinks. Oh, okay. Oh.
When Ms. Love just said, "Oh shoot," this is not a quote, but something effective. "Oh shoot, we must turn this over." That was before giving it to Agent BERNI. So what happened on that date of the "oh shoot" to we get it yesterday and we don't get it? Oh, this is new stuff. Let's talk about it.
So we are one team, but we have many members and parts. But I will get the date. But I can tell you that there was a realization that we do need to turn it over.
Yeah. When did that realization occur?
I will find out, because it was not mine. It was not my realization.
Okay.
So I'll find out. What I'm saying is,
who's in charge of the team?
We are. And so therefore it's mine, generally speaking. I'm saying that in terms of a date certain, there was communication internally. We looked at it. We were looking at everything we had to turn over, and we were looking at anything that we haven't turned over. Collectively, we realized, oh my goodness, this has not been done.
All right. And you don't know what date that happened?
No, that's what led to turning it over.
On Monday.
Yes, this weekend we were talking about it and we turned it over.
All right, so sometime over the weekend is when the realization occurred. Oh my gosh, you knew you hadn't turned it over. Oh my gosh, we need to turn this over.
Oh my gosh, it has not been turned over and we need to turn it over.
Okay.
This trial needs to end, or there needs to be a set cutoff of no more discovery. What are we doing?
About when when we get the affidavit search warrant for the cell records, we'll know the date that occurred.
That is correct. We're working on that.
And it did not occur to anybody at that point in time that this is information to be shared with the defense.
When the court says at that point in time, you mean with the affidavit for the search warrant? When the search warrant for the records were obtained?
Yes, right. Obviously not, since you got them in the fall of 2023.
And because the information that the search warrant was based on had been provided. So we weren't thinking along those lines then.
Okay. Had you at any point provided information that the phone number that y'all all know about is actually DeMarco Boyer? Did you ever before Monday share that information?
No.
Okay. All right. What was the nickname?
Unk is the name that's listed on, I think, in the wiretap. I think it's Unk.
Unk?
At this stage, which is mid-trial, anything else, whether Brady or not, that you think might be relevant to either the state or the defense in trying this case that you, the state, know of that the defense still does not know of?
Too long of a pause, Miss Love. What?
And you may want to huddle with whomever comprises your team. Y'all all put heads together and really, really, really think about that, and then get me an answer after lunch, okay? Can you do that?
Bro, Miss Love isn't qualified anymore. Her and Miss Hilton have this trial in the ass, bro.
Yeah, we'll recess in place until you come back from whatever you're going to find out at the door now.
The state's theory is that Mr. Williams is in charge of a gang, and the gang does...
I just want to pause it here. Thug and Shannon both knocked out, bro. Look at this.
Gang does crime on his behalf. He asked for it, and they do it. We deny that. I heard the court say, and I heard prosecutors say...
Them boys tired.
...that this is inculpatory, no exculpatory. Everything could be inculpatory or exculpatory.
Okay, I didn't say it's inculpatory. I don't know. If I said that, I'm repeating the state's maintaining that it's only inculpatory.
I understand.
Okay,
I appreciate it. And all I want to make the court aware as you go through decisions, if we knew about Mr. Boyer, then what I would have done is found out if he has a lawyer, because he's in custody, it sounds like, contact his lawyer, ask if I could go with a lawyer, and Miss Adams, I said me, and Miss Adams, and an investigator, and interview him. And he may give information that's very hurtful to me. He may give information that is very beneficial to Mr. Williams. I don't know. My point is, though, that the state has no ability to know what's helpful or hurtful to Mr. Williams, and we have a right to investigate. So
I'm not refuting anything regarding the need to provide it to the defense and whether it's inculpatory or exculpatory. I just wanted to make clear and make sure that I told the court and the defense that we're not asking to use it. We just wanted to, out of an abundance of caution, in the event that it is in some way, in any way exculpatory, give it to the defense. We're not trying to use it.
Okay. All right. Thank you.
So now they're going over more quindarius Zachary statements.
My understanding from my recollection is that Investigator Dennis has never spoken to Mr. Kendricks about the murder of Donovan Thomas. Okay, that's my understanding. But either way, whether he's spoken to him or not, I believe he's just using a technique to try to suggest that Mr. Kendricks has said things.
Right.
Either way, he's putting words in Mr. Kendricks' mouth. I don't think it's appropriate for Investigator Dennis to state on a out-of-court statement for the jury to hear what Mr. Kendricks supposedly told him.
When Investigator Dennis says that Yak said something different, and nowhere does he assert, hey, I did this. Everyone knows there's not a dispute, I think, that Mr. Kendrick made a statement and said something different. When Investigator Dennis says that Yak said something different, just to give the court some context, the 2015 interview that this witness gave contained inculpatory information concerning Mr. Kendrick, Mr. Stillwell, and others. Has been circulated that interviews have been conducted. Jail calls reveal that co-conspirators, at least alleged co-conspirators, people that we allege are co-conspirators, are aware of the content of some of these interviews. And at this point, Mr. Zachary is now saying he's backing away from it. He never denies that defendant Kendrick and defendant Stillwell said to him the things he said in the 2015 interview.
Right.
But now he's proffering theories about their actual involvement. He said, yes, they said that. They did say it. And when Detective Dennis says, after Mr. Zachary gives him a rendition of events.
I just realized Mr. Weinstein isn't even arguing about Yak Gotti's statement because Mr. Weinstein's not there. I don't know who that is next to Yak Gotti right there on the left, but shout out Max for arguing this. He doesn't really have to. It's not his client technically, but obviously that he wants to get statements out of co-defendants.
Investigator Dennis on 116 line 8 says Yak said he was on his way to Bush's house and they saw Nut at the barbershop and they made the call. I don't know if Mr. Kendrick's saying that to any law enforcement.
Well, we ought to be able to check that.
My recollection of the statement, and Mr. Weinstein's most on top of what was said in that interview and what portions were suppressed. He said, I did not have anything to do with this killing. I went to my girlfriend's house. That's my alibi. I don't know. So the state, yes, he said he was in a car with her going to her house. He never said seeing Nut at the barbershop and making a call. That was not stated. So that's a misrepresentation of Mr. Kendrick's statement, first of all. And secondly, I mean, it's just completely confusing to the jurors.
Okay.
Did he say that or not?
And Mr. Schardt is correct regarding Mr. Kendrick not saying we made the call, but the part where he says he was on his way to his house.
Right. That's not the part at issue. It's and they saw Nut at the barbershop. Does Mr. Kendrick in his statement say anything about seeing Nut at the barbershop?
My memory is that he doesn't say they saw Nut at the barbershop.
Okay.
My memory is that he doesn't say that they saw Nut at the barbershop.
Okay. And
but that he was on his way to, so I'm not disputing that part.
Okay. So then that part needs, I would think, to be redacted out because it is confusing.
I have no problem with that.
Judge shot it down. She figured it out. Not surprising. Miss Love's misrepresenting a statement.
All right. As to the next one, Mr. Schardt, your objection is to the investigator's statement, right? Or also.
It's the investigator's statement, yes.
All right. So the objection as to the 41 is that it's speculation.
It's a hypothetical. If it did, I'm reading that is if they did it. I don't think Demekian had anything to do with it. Why? He ain't take it like you said, look at me and like little brother. I think in context, what he's articulating is people look at him as a little brother. And I mean, he wasn't there. He's not offering firsthand knowledge. He's just giving his theory that I don't think Demekian would be involved with something like that if they did it. And I just think that's speculation.
Is something that is repeated throughout Mr. Zachary's interview. And in as much as there is information that Demekian gave to Mr. Zachary, similar to the way that he gave information to another witness in this case, as you understand. The reason that I believe that this should remain in is
this motherfucker Demekian just be telling everyone everything in terms of like other people in YSL. He was just telling everything.
Mr. Zachary, at one point, Mr. Garlington was charged, but not by the state. And Mr. Zachary was in a position, he was with Mr. Garlington, Mr. Kendrick, and Mr. Stillwell after the murder, following the murder. So in as much as he makes the assertion, he later says more stuff like, Demekian never told me that he did it. He talks about what each person said to him.
Valid objection. So we're going to strike 118.24 through 119, line 5.
So the fact that Mr. Garlington is sharing with Mr. Zachary events that happened, I would argue still falls in the co-conspirator exception, admissible as a co-conspirator statement.
There's so many things that would never be allowed in other types of charges, not RICO, but she gets so much shit in that are co-conspirator statements, the defense can't even cross-examine any of these people. It's absolutely insane. Anyone deemed a co-conspirator, pretty much anything they said can come in, even if it's false, a rumor they heard from someone else. That's pretty much what's happening here. Tons of it. I've seen it for months, dude.
Mr. Garlington, 3 other individuals, I believe it was 3 other individuals, including my client, Mr. Stillwell. Warrants were taken out for them in around October of 2015, based on the testimony or the word of a gentleman named Nicholas Robinson, or Spencer Wright, depending on when you ask him. He gave these statements to police. Investigator Thorpe went and got warrants for these gentlemen. On subsequent review of the footage from the scene, Nicholas Robinson was not present where he claimed to be on the scene. So at the time of giving these statements, Mr. Garlington, and jail calls that I believe reflect this, Mr. Garlington is in extreme prove my innocence, shift blame mode. He's not in any sort of co-conspirator, we're in this together mode. He is asserting to anyone and everyone that will listen is, I didn't have anything to do with this, I'm wrongfully arrested. He's asking people to get video from the McDonald's on Cleveland Avenue, video that we still don't have, that will show he's innocent. Right. And so these conversations that quindarius Zachary is saying Mr. Garlington had with him, from my perspective, for the purpose of asserting his innocence and shifting blame to others. So that would not fall under 801D2E.
Interesting perspective.
The answer being that Garlington says that Woody picked him up after the shooting. That's not, hey, Betty, I've got absolutely zero to do with this. It is still something that could in some way be against his penal interest. So I am going to find that meet that co-conspirator exception. So I'm going to overrule the objection on that one.
I take exception to Investigator Dennis relaying in a statement that would be heard by the jury what Demekion Garlington supposedly said to him. Demekion Garlington is not going to take the stand, to my understanding, in this case.
All right. Is Demekion Garlington's statement going to come in?
No, his statement to law enforcement will not come in.
Okay. And is it your objection that the questions by the investigator are based on hearsay?
The questions are based on hearsay. Investigator Dennis, he's saying that basically my client is involved in a list of shootings, and then he eventually lists them. One of them, I think we already discussed, Lucci's mama house, is the words he uses.
He said Shannon Stillwell shot up Lucci's mama's house? That's crazy.
He's just recapping what Zachary said, and what Zachary said has already been ruled coming out. He said he did the bus. We've already established that Mr. Zachary wasn't present at the shooting of the bus, so Mr. Zachary wasn't allowed. We're not going to play what Mr. Zachary said regarding who did the shooting.
I think should be left out, but of course co-conspirator.
So I don't know why we would allow Investigator Dennis to repeat it. And in the murder, I mean, that's a question for the jury here. And I understand that there's certain things that are helpful. Mr. Zachary says, I don't think he did the murder. I would like that to come in, but not in the context of Investigator Dennis listing a bunch of other shootings that are on this indictment that he's concluded my client has done.
When Zachary says it's probably so many shootings, and then later on he says they go all the way back to 2014. He's clarifying information he's giving to Dennis, and he is giving information. We would argue he does have a basis for knowing. I don't have a problem taking out that he did the murder. But the three biggest ones.
He was quiet until it was time for some action, and then it was almost like sickle.
Okay.
So he's like basically saying my client is, a leashed pit bull.
Any statements like that from the detective should not be shown to the jury. I understand the whole co-conspirator bullshit, but not really actually, but a detective should not be giving input on stuff unless he's on the stand being cross-examined, obviously.
So 11 through 14 are redacted by agreement on page 141. 15 through 25 of that page I'm going to permit in.
The entirety of this testimony, and the context of it is that this is a conversation where Mr. Sprinkle's involved, the detectives are involved, and they're talking to Mr. Zachary about what they believe to be a beef, for lack of a better word, between Mr. Williams and the Quantas Lamar, gentleman known as Rich Homie Quan. In short, my objection for this entire segment of the conversation, Mr. Zachary is opining about the reason that, well, first he's opining that there's a beef, in fact, the beef between Mr. Williams and Mr. Lamar, and he opines as to what the reasons are. The detectives are kind of interjecting their own take on what has happened and why they fell out. And if the most telling part is if you look at Mr. Lamar and Mr. Williams fell out, and Birdman and Rich Homie fell out for some reason, I don't know, he says, continues on to page 149 where the investigator asks him because he wouldn't sign, and then Mr. Zachary says, I don't know, I guess. That kind of encapsulates the fact that most of what he's talking about is what he's heard, what may be on the street, and there's no real basis where that speculation is coming from. So I ask that all of that be kept out because it's just speculative.
All right. Well, I think that you're right with regard to, Birdman and Rich Homie having fallen out, and, the reason that might have happened being speculation on the part of Zachary. But that's kind of a separate topic from everything that they're talking about before.
Mr. Lamar is a state's witness. He's on the witness list. Birdman is on the state's witness list. Mr. Brian Williams. We've been noticed that he may potentially be called. And so these are witnesses that if the state intends to prove.
The state always tries to get in shit about beefs Thug had with Lil Wayne or Birdman, right? And the game. And it's not through Birdman or Lil Wayne on the stand. If they wanted to come in, they have to call Birdman or Lil Wayne on the stand. But obviously, Birdman or Lil Wayne not going to do that.
Their theory, I'm going to say it's their theory, that there was this beef between Mr. Williams and Mr. Lamar, and that's relevant in some form or fashion. They have witnesses that they can call to do that.
Yeah, they can corroborate their own witness testimony with something else if they got something else. So that's not an evidentiary objection. That may just be wishful thinking.
Well, yeah, I don't know if they're going to call those witnesses.
I don't either.
And if they want to corroborate, if they call them and they want to corroborate it, then they can say perhaps that Mr. Zachary knew this in some form or fashion, heard it from those witnesses, but there's no indication that this is anything other than speculation on the part of Mr. Zachary.
His basis for knowing that information, or at least broadly that information, is when he's talking about being on tour with defendant Williams. During this, about Young Thug getting up on stage in March of 2015, calling Rich Homie Quan, Big Homie Quan. And Mr. Zachary says, I was with him. Yeah. ADA Sprinkle says, you weren't there. And Zachary says, I was with him when he said that.
Yeah.
So these statements provide a basis for Mr. Zachary's knowledge of whether or not defendant Williams and Mr. Lamar continue to work together.
He's got a basis for knowing what he is saying. Agree that's kind of a different topic and speculation. So I'm going to strike that. And
Rich Homie Quan, the fact that he knows Jeffrey Williams, the fact that he knows where someone lives, the fact that he went and let someone in does not give him the basis of knowledge of what is in someone's mind or why someone fell out. That's what the conversation is about.
All right. So Ms. Love, what's your response to that?
It's a good point for Mr. Adams.
I would argue that his proximity with Mr. Williams and
I'm going to say it's his firsthand knowledge. It doesn't matter.
his association and relationship with Mr. Williams, as reflected in the fact that he's always at the condo, even on occasions when Mr. Williams is not there, is the basis for a knowledge of why they don't work together.
Okay. And you have evidence that establishes their close relationship at this period in time?
Yes, his words, Mr. Zachary's words throughout the interview
All right.
are reflective of them.
Okay. Then I will stand on my prior ruling. Okay. But what about the rest of 154, basically? That's the investigators counting bodies. And all Zachary says is, these are like, who are you talking about?
They try to sneak that in. Investigator counting bodies. And Zachary doesn't even know what's going on. Great.
I don't have any problem. I don't have any objection, rather. I'm sorry.
Okay.
You can't see it on here, but on the tape, I can give you the timestamp. He says, they say DK and Nard did it.
I just don't understand how that's not hearsay.
It is hearsay. It's hearsay that is being permitted under the co-conspirator exception.
Disaster. What an absolute disaster. That's so funny. Shard's like, I don't know how that's not hearsay. It is hearsay, but co-conspirator.
There is a jail call where they say Lil D told her, Lil D was telling. And Mr. Zachary, now being aware that people know he gave that August 2015 statement, is trying to come up, pull back some of it. So we want to put it to show evidence of the enterprise itself, how it operates, what happens when people tell, and how people react. All of that, we argue that it's relevant evidence and not just hearsay.
Okay.
So they want to show it because people found out he was snitching and he's trying to backpedal on it. Whatever, dude.
A way to bootstrap hearsay to say we want to play the hearsay to show the way people react to someone saying the hearsay. But my objection is, I'll just say, Ms. Love just keeps saying, quindarius Zachary is saying what they say, or they said. On 157 line 7, in my notes, quindarius Zachary it says no, and in indiscernible, what indiscernible is Demikian says. Demikian says that they were all in the car, they were all in the car. In what car? In they rental car, is what it says on the tape. So he's repeating what Demikian Garlington told him in the jail while he's trying to assert his innocence. And Demikian is putting himself out as being dropped off outside the car, and then eventually putting Shannon, Mr. Kendricks, Mr. McMullen, and Mr. Cobb in the car. So it goes back to the same argument that I'm making, and I know Your Honor hasn't necessarily agreed with me in the past, but I still have to make the argument that these were statements that Demikian Garlington is strategically giving to Mr. Zachary, not to further any conspiracy, but to get out of jail. And he's put his narrative out there, and that falls under, we provided the cases to the court previously, Stafford, Wilkins, and there's two others, but it's spilling the beans.
By Detective Gaither made what do that? And Mr. Zachary says people who killed him, Shannon, Yak, Nard. And then Mr. Detective Gaither says Nard in jail for kidnapping. Mr. Zachary says, yeah, and Duop. He's then asked what Duop looks like. Then Detective Gaither says, how do you know this? Mr. Zachary says, because they told me. Detective Gaither says, who told you? In August 2015, quindarius Zachary says, Shannon and Yak told me. Detective Gaither says, why did they tell you that? Mr. Zachary says, we were at the house talking about it. Detective Gaither says, which house? Mr. Zachary says, Thud's house. The argument that this information came from Demikian Garlington, who was just trying to clear his own name, is belied, I think, by the information that the court will hear Mr. Zachary give in 2015.
Okay.
I don't dispute that Mr. Zachary has said that he's claimed that Mr. Stillwell and Mr. Kendricks made statements to him. That's not the point. And when we deal with those statements, we can we'll address those statements in the arguments. But in this particular statement, my notes say on line 7, Demikian says that they were all in the car. They were all in the car. This information that we're dealing with right now, the source out of Mr. Zachary's own mouth, is the source is Demikian. And that's what's on the table before us right now.
All right. So if we go back to 156 line 7, which is where this objection, I think, begins. No, it doesn't. But if we go back there, at that point, they're talking about what Zachary told them way back in 2015, the source of which was the conversations amongst people at Mr. Williams 1 through 3. Seems fine because he has a basis for knowing that is from before.
About the number being on the wire. Within the discovery that was served in 2022, the phone number that we've gotten the records for and the last name of Mr. Boyer is provided within the Sumlin-Dorsey conspiracy. And I said wiretap. There are 2 wiretaps that were gotten. This name and this number appears in both, and the name for the number appears in the Sumlin wiretap.
All right, and you produced that to the defense as a part of the Sumlin-Dorsey conspiracy package of discovery in 2022. Is that what you're saying?
Yes.
The discovery in this case, including, I call them dumps, or that jail call, which I guess is Mr. Dorsey talking. Comes up on your screen. It says 04282022. I guess that's the date. 4/28/2022. Dorsey and Boyer. Okay, it doesn't give a first name. It just says Dorsey and Boyer.
Okay.
There's no context for us to know who Boyer is. And this is the call that the state is saying puts us on notice. Mr. Boyer is somehow suspected and involved in the drinks murder.
Okay.
This is the call, and I just want to play it.
Okay.
Did not represent and are not representing that. The content of that call puts them on notice. What we are saying is that the wiretap, the content of the calls in the wiretap are the basis for our search at getting the records. That's what
Okay,
put us on
and the connection to the drinks murder, but it is this service of discovery that says, hey, that phone number from the wiretap is connected to the name Boyer. Is that what you're saying?
Yes, that's what we're saying.
It says
That's all
Boyer,
I'm
and it just says Boyer. And if,
Okay.
and if you play this, I would like to be able to play
Sure.
this. Someone says, I'm in traffic, I'll hit you back.
All right. They say they're not using it in the drinks murder evidence anyway. That actually, I think, takes care of Mr. Williams' motion in limine filed recently within the last hour or so, I think.
The state's not going to use it anyway, the information they gave over late. So pretty much this has all been a big waste of time.
And then there's a second part to it. We received on Monday, for the first time, Agent BERNI's expert report as to a April 26, 2015 shooting of Mr. Carter's tour bus.
Okay.
It's been referred before this honorable court as the Lil Wayne bus shooting.
Okay.
There should be no discovery about the Lil Wayne bus shooting, dude. How is that possible?
They've already put up painfully. It took days tracking phones. They have 3 to 4 different exhibits to your honorable court's right of your bench. They're against the wall, or they should be. I believe that's what they are. Anyway, the point I'm trying to make is now, for the first time, we're getting another expert.
Okay.
Never gave us this information before.
Insane. A whole new expert.
The issue, I realize, is way late discovery is what is being alleged. Wherever the cell phone location is, the state has represented that they do not intend to use this. I'm granting the motion limine. At the point in time when you think it might be relevant to have a plot of whatever cell phones might have been involved. We've already heard everybody's testimony. Man, we'd like to shore that up with some expert rolling back in here and taking the stand again. We're going to get him to plot this. Would it have been possible at that point in time to share with the defense, hey, y'all, we're going to have our expert that y'all already know about anyway. Go ahead and plot this too.
Yes, that would be, yes.
Okay. Why was that not done?
Because the state does shit like that on purpose. The silence.
So, Bernie did not testify about these. He has
I know.
not. Okay.
Don't let it come in. We're 19 months into the trial.
I don't have, as
A
to,
good answer. I mean, and the answer could be because, man, there are only 24 hours in the day and this is chaos and, you know, we're doing the best we can. That could be your answer. I don't know. It's still not a good answer,
yeah, we know.
but let's just maybe nip this in the bud. Because I did ask you also to, at the lunch break, huddle with your team and see if there might potentially be anything else outstanding, whether Brady or not, because none of this sounds like Brady. It's just information that might come in trial. It would be, you know, just kind of like the way we're supposed to try cases is to sort of share each other's evidence to, you know, with the other side so they know what to expect. So were you able to sort out yet? Is there anything else out there in the universe that you think you're going to use? As this trial is going on, first, if there's anything outstanding like that, whether you've got results back or not, or if you're just like, after somebody testifies, you know what, this would be a good thing.
Okay.
Share it in a timely manner, which is like, not necessarily at the time it occurs to you, but at the time you decide to do it. Don't wait for the results to get back. Don't wait till you're going to call the person to the stand. At the time you say, we're going to do this, you give that information to the defense, okay? And then when you do get the results back, you can say, we're not going to use it after all.
This judge isn't declaring a mistrial. Those are all going to be denied. I promise you that. She's talking to Miss Love like she's 5 on how to give over evidence to the defense. So this trial is going to continue. I promise you that.
This trial was sort of, everything was on a rolling basis.
Yeah,
And I can't do a whole lot about that. Moving forward, that's what it's going to be.
Everything was not on a rolling basis.
Well,
And the rule that you just implemented was already already the rule.
Okay.
Sheesh. There was already a discovery cut off.
Judge Glanville at a certain point, because we were receiving late discovery disclosures all the time.
Okay.
And at a certain point, he said he was fed up. He spoke to the state. He said he was drawing the line there.
Okay.
And that any late disclosures after that, and he did exactly what you did today. Maybe not in those exact words, but he said, is there anything else?
Okay.
So he gave the state this opportunity already, and he told Ms. Love specifically that if any other late disclosure of discovery came after that date, that it would be met with remedies and sanctions. So we're here again, and I'm just asking that before you exercise patience,
Don't exercise patience.
That's attorney Westmoreland. Real quick, I wanted to read this Thugger Daily tweet. I remember when this happened. At one point, this state gave over discovery and they accidentally had on it, "Do not serve yet," so that the accused will be blind to this mandated discovery until over 14 months after. So they basically told on themselves that they withhold discovery from the defense. They put on it, "Do not serve yet."
Yes.
And,
I can
and
see
so
that.
why is an appropriate sanction not at this point saying you cannot use that information through, period. You can't use that information. I can't let Bernie testify to that.
Because two reasons. The remedy of exclusion, one that is extreme, and generally it would be appropriate when there has been some kind of harm and there has been some kind of bad faith.
How do we know this has been bad faith? You put "do not serve yet" on other documents over a year ago.
Yeah, I understand. So how is it not bad faith? And I don't mean this personally, but how is it not bad faith when you've been ordered by a court, probably orally and in writing, that you need to produce things as they come into being and as you know about them, and then you don't do that?
Bad faith would be holding it back for some kind of advantage, tactical advantage.
So how is it that it came out on Monday or occurred to y'all over the weekend and you produced it on Monday? Is it because because y'all finally got together and said, all right, y'all, what else is there that we ought to be giving them? Why 2 months later?
So
Oh my God. This trial is actually funny at this point.
it may have been that as we were looking at 30 witnesses out and looking at Bernie,
Okay.
we realized, oh, Bernie.
Okay. So it basically was just the court saying, it's time to get organized and it's time to share the details about what your intended trial evidence is going to be, that finally made y'all get organized enough to realize, oh shoot, there are some things we have not shared yet. Fair?
It is the court's order that got us to do that.
Okay. All right. So that is probably not bad faith. That is it being swamped because there's a lot of evidence.
Oh my God. I don't care if they're swamped because there's a lot of evidence. We're 19 months into this trial.
arguing as if it's a first argument to you because they know you haven't been here for 19 months. These arguments, I've heard them so many times, it's countless.
I understand.
Right. And for the state to argue it's not bad faith, I'll give you an example of things that we've been through before we had the opportunity for you to be presiding. The state's been caught before. Specifically, I remember a late discovery disclosure that once it was disclosed, it actually had a comment on there that was supposed to be internal that said, "Do not serve yet." They did it on purpose. And how many times can you say, oops? How many times can you repeatedly, systematically make the same mistake as an experienced litigator and say it's not bad faith? I'm just asking that the rules be enforced, because if they're not really rules. They're just aspirational.
All right. I understand. And the answer to how many times can it happen? Maybe 0 more times. Okay.
So she's saying 0 more times. State's not going to be allowed to do it, but she's letting it pass right now. All right, that's pretty much it for today. No surprise, the state screwed up even more. They were hashing out a lot of statements, so it's pretty tedious. Join the channel membership is only 10 cents per day. I have merch dropping pretty soon, within the next few days, hopefully. I'll put the shirts on the screen right now, so look out for those. Love you guys. Peace out.